which could be the case if we had a written employment agreement, but here, aren't findings of fact relevant to our analysis of whether an employer-employee relationship exists?
Well, to a certain degree, I do believe the findings of fact are relevant. I raised both issues. I raised de novo as to the issue of employment contract, because I think this court can find, regardless of whether there was a written contract, and there wasn't, but I think this court can find, based on an oral or a written contract, that there was a contract of employment. And in this case, the judge found that the claimant was an employee. Of course, she didn't say an employee of who, but the other possible employer was not brought into the case, at least not as of yet. So essentially, she found the claimant was an employee, which means he was paid wages for his services, and also that there was a contract of hire, but she never finds that there was a contract of hire or wasn't a contract of hire with IX. And of course, it's our position that the facts in this case fully support that there was a contract of hire. And the judge focused on one factor, in my opinion, one factor only, and that factor was supervisory control. And this court has held previously that supervisory control is not controlling.
It's a pretty important factor, though, isn't it?
Well, overall control is important, but control could be, in this case, there are a lot of facts actually that support control by IX, and that is number one, there was a long-term relationship between the two of these people. I believe it was in excess of 15 years. I don't remember the exact amount of time, but he did frequent jobs for IX. IX was a subcontractor, self-proclaimed subcontractor. He was not a GC. He could not work on a contracting job site without a GC overseeing them. So he had
Go
relations.
back to the oral contract between the parties. What evidence was there in the record that there was a contract that the scope of work extended to the 9901 job site?
Well, at the time, the claimant was working on another Houlihan project through IX, and he was being paid $10 an hour. It was the same sort of arrangement that occurred. It was called Vertical Cable, I believe the project was. And at that time, Houlihan contacted IX, the owner, not really the owner, but let's say the principal of IX, who was in charge of the day-to-day operations of that company, and said, is the claimant available to work on this other project that I have? And so IX, the proprietor of IX, Carbonell, contacted the claimant and asked if he was available, and he said that he was, and they agreed that it would be the same deal. He would receive $10 an hour. Carbonell and Houlihan agreed that the IX would get paid $17 an hour for his services. So the claimant got $10 an hour out of that $17 an hour. So that is evidence, and evidence, of course, of dealing between these parties. This is the way it always worked. It had been going on for 15 years. Carbonell would always contact the claimant and say, hey, are you available to work? If he was, he would go to work and he would do whatever it was that the employer, or my employer, wanted.
Specifically, what are you alleging is the problem with without compensation? What is the defect, and what are you asking us to do?
Well, I think there's a couple of defects in the compensation order, actually. If you're not going to find that there was a contract of hire as a matter of law, then there's a huge problem with the findings of fact. The judge made only really about 3 findings. One finding was the claimant was an employee. Like I said, didn't mention an employee of whether it was IX or Houlihan. It's just sort of out there. The claimant was an employee. So that means the claimant was an employee because he received wages and he had a contract of hire with somebody. So the other finding was that Carbonell was never on the 9901 job site, and that there was no supervisory control. That's the essence of the finding. That is the essence of the conclusion. She found he was not on the job site, so there was no supervisory control. But there are a whole lot of other facts that weren't considered by the judge. Number one, I think she needed to make a finding as to whether there was or wasn't a contract of hire, because that's the first element when you're looking to whether or not there's an employer-employee relationship. The first question is there a contract of hire? This court actually recently held that in the Jenks case, which is obviously a distinguishable case in terms of the facts, but nevertheless, it still decided the issue of whether there was an employer-employee relationship. And the first thing the court looked to is the definition of employee and the fact that the claimant met actually found as a matter of law that the claimant met the definition of employee in that particular case. That wasn't a situation where there were two possible employers involved, but it was a situation where the claimant was attending an orientation, and the question was whether or not there was an employment contract had been formed at that time. And based upon the circumstances, this court found that an employment contract had been formed.
Well, going back to the right of control, or the exercise of control, so the JCC found that there was no exercise of control. You disagree. So give us an example based on the evidence where there was control.
Okay, the control wasn't supervisory control. I agree that Carbonell was never on the job site. He was never once on the job site at the time the claimant and one of his other employees was on the job site. So essentially the elements of control are that Carbonell told the claimant, first contact the claimant, are you available? Yes, I'm available. Then they agreed the terms were going to be the same as it was in the vertical cable job. Then he told him when, where, and to show up and what to do. Essentially told him, do whatever Houlihan tells you what to do.
That was going to be my follow-up question. Isn't that basically disclaiming any type of control when Mr. Carbonell says, well, you do whatever Mr. Houlihan says to do?
I don't think so. I mean, usually control is whether or not, somebody has the right to tell somebody, to go somewhere. I mean, he is controlling an element of this. That is, go there and do whatever he tells you to do. And I mean, clearly the guy was there to do a certain job. His job was to just basically be a general laborer. He was toting things around, cleaning up, things of that nature. And the other huge element that was never even discussed in the order, and there's conflicting evidence on the issue, which is discussed really in point 2 of the brief, and that is the question of who had the right to fire him. There was a dispute. The claimant says, "Oh, Carbonell had the right to fire me," and Houlihan basically said that no, he didn't have the right. And Carbonell says, "Oh yeah, Houlihan had the right to fire."
Well, it's a dispute that Houlihan could have told him to leave the premises,
Yes.
to get off the job, and then isn't that, if he's an hourly worker, isn't that effectively saying, you're fired, you're not going to get paid for this job anymore?
Well, I don't think so, because he wasn't paying the claimant to begin with. But I say you can exclude anybody from the job site if you're the contractor on the job site and you're not happy with a sub or a sub's employee or what have you. I mean, you're in charge of that job site, so you should be able to exclude anyone. I mean, just think that the factual findings are wholly insufficient if you're going to go that route. And in terms of also the course of dealing between these parties. The course of dealing, and also another factor is the fact that it wasn't just Houlihan that the claimant worked for. When he on these projects, there were other general contractors. It was whenever IX called him, it just depended on who the contractor was at the time. In this instance, Houlihan just happened to ask because he liked the claimant, thought the claimant's work was good. He thought that IX hired good people and always sent him good people, and therefore he wanted to continue to use, he liked the claimant's work in this instance, so he wanted to continue to use them. So, just getting to the fact that, Carbonell, excuse me, this court has actually held in Hamilton v. Shell Oil Company that this court, that mandates the first factor to be considered is the existence for contracted hire. And again, like I've said before, there literally was no finding in the order one way or the other. The judge could have found or should have found that there was no contracted hire, and that's why, instead of considering she also mentions that there are 4 factors in the and that is selection and engagement of the servant. JCC made no findings whatsoever, and there was uncontroverted evidence of longstanding relationship and course of dealing between Carbonell and the claimant. Carbonell set the hourly rate. Also, the claimant testified that he never worked for Houlihan. Houlihan never paid him. And there were all kinds of conflicts in the evidence in terms of who had the right to
So are you asking us to send it back to find that Mr. Zamora was IX's Design's employee? Or are you asking us to send it back so that the judge of compensation claims can make some of these ultimate findings that maybe they connect to?
Well, I'm asking, number one, I'm asking this court, actually, I think based on the evidence presented, that this court can find that there was a contract of hire. That's first and foremost, as a matter of law. And this court has found that situation before. And secondarily, if you don't buy that part of it, then I would say I'm looking for a remand for the judge to make appropriate findings, because I think the findings literally are wholly inadequate. I mean, I know Mr. Rogner argued in his brief. I forgot to reserve time for rebuttal, I just realized.
How much time do we?
2 minutes, and I'm done.
Okay. Well, you can finish up as much as you want, and I'll make sure you have your minutes.
Okay.
And I have a question
okay.
in terms of, the sufficiency of the JCC's findings. We've said on multiple occasions that the primary and essential element is a degree of control, correct? So if we find that there is competent substantial evidence to support the findings on control, why should the JCC need to apply the other factors? That's the essential component.
Well, control is the essential component, but not supervisory control. And I would point you in this case, it's kind of a lengthy case, but it's an older case, and actually specifically says that supervisory control is not the only issue, and does not control, actually. I'll tell you. It's Austin versus City of Duval, cited in my brief, 657 Southern 2nd, 945. It's a 1995 case. Very interesting and lengthy case, but the workers there were supervised by an on-site manager that was not the employer, and this court specifically found in the end that there was no special employee. I know this isn't a special employee situation, at least not yet, but no special employee relationship found, even though the claimant was directly supervised by the school. All other indicia, like the claimant was paid in that case by the actual employer. Actually, in that case, that was an immunity case, but it's the same standard, regardless of whether you're looking at an immunity or whether you're looking at a workers' comp case. So what I'm saying is that it needs to go back for the judge to consider more the other control factors that we're discussing
Well,
here.
the JCC, though, did go on to say that Mr. Carbonell didn't exercise any control. And there is testimony and evidence that's consistent with that ultimate finding.
Well, when she says it doesn't exercise any control, I think she's relating to on the job site. That's specifically preceded by her saying that Carbonell was never on the job site, and then she says he never found. I realize there's never any control or any supervisory control. He was never on the job site. Everyone admits that. But there are, like I said, there are more indicia of control than just who's supervising him on the job site. I'm about out of time, so maybe I'll reserve my 12 seconds.
Well, I'll tell you what, I'll give you 2 minutes of your rebuttal time. Of course, Mr. Rogner will have an additional 2 minutes if he needs to use it also.
Thank you, Judge. May it please the court, my name is Bill Rogner. I represent IX Design and Normandy Insurance, along with my co-counsel, trial counsel, Richard Studemeyer. Your Honor, the absolute best case for any claimant lawyer is when you know for certain that one of two insured employers is definitely responsible. Because all you do is file a claim against both, you sit back, let them fight it out, and you're guaranteed to win. But for some reason that I cannot fathom, the claimant's trial counsel below decided that he only wanted to proceed against IX Design and resisted even our efforts to bring Houlihan Construction and their carrier into the case. If they had done that, then this case would have been over because the judge would have awarded benefits against the actual employer in this case, which is Houlihan Construction.
Explain to us the relationship between the claimant and your client, IX Design. Because it's not an employee-leasing company, it's not a staffing agency.
Right.
And you're saying it's not an employer-employee relationship.
Right.
So what is it?
Well, Your Honor, I tell my non-workers' comp lawyer friends that workers' comp, which is my life, is its own little universe. And we also have this little bizarro sub-universe within workers' comp. It's construction projects. And what we see is an infinite variety of very odd things that go on in construction projects. And the only reason that I think it's interesting, this case, vis-a-vis us, is because the way the money was paid. The claimant's working by the hour for Houlihan. He was on that job for 6 months. He went every single day, reported to Houlihan Construction supervisors, did exactly what Houlihan Construction supervisors told him to do. He was a construction laborer on a Houlihan job. The only thing that's a twist is that the money that was paid by the hour wasn't given directly to him. Instead, Houlihan sent it back over to IX Design. And then,
Yeah, it gets weird, because
yeah,
then Mr. Carbonell
yeah.
pays with cash for a personal check.
and pockets maybe $4 or $5 an hour himself, okay? So you would think that in the real world, people would find that shocking, but in the construction world, I don't find it shocking at all. And in fact, we presented an expert witness by the name of Fred Atwood to explain it. He is a former commercial contractor and currently a board-certified construction lawyer. And we brought him in because of this oddity, right? And he explained, look, this is really common, and here's why. Zamora's a good employee. And IX Design, which only does stucco and lathe work, by the way, and there was no stucco or lathe work ever done on this project, and that's all IX does. They have an incentive to keep all of their employees busy as best they can because the construction business is cyclical. IX Design, in fact, went all these 6 months that he was on this job, and they had no stucco or lathe work to do. If they don't figure out something to do with Mr. Zamora, he's going to go get another job. So in this case, what happened and what Mr. Atwood explained happens all the time is that these guys all know each other. And I got no work, Paul's got work, go see Paul, he'll put you to work. So he shows up at Houlihan, and from that point forward, he worked there. IX Design had no contract on that job, they did no work on that job. Carbonell never stepped foot on that job. The only reason he knew that the claimant was now at 9901 is because when the money was coming over, it no longer said vertical cable anymore on the invoices. It now said 9901. That's how we found out the claimant went to 9901. He never told him to go to 9901.
Mr. Rockman, if you could address the argument by the appellant that the JCC's findings on control were insufficient
Sure.
to require a remand.
Okay. They didn't preserve it. That's my first response, right? No motion for rehearing. And this is exactly the type of problem that screams for a motion for rehearing. Because if you reverse it, it's a completely Pyrrhic victory. Here's what happens. Case goes back, judge goes, okay, they said I didn't write a good enough order. The judge will write the order instead of, the judge had 25 pages of findings, or 25 paragraphs of findings. The judge will then say, I find that Carbonell was never on the job site, instead of just simply reciting all the evidence that Carbonell was not on the job site, right? The judge made the only finding of fact that really matters, which is that there was no direction and control by IX Design. We followed and so they had an obligation to follow a motion for rehearing, allow the judge to correct this readily correctable mistake if in fact it was a mistake, right? Now, as far as the law is concerned, Florida follows the restatement of agency. Employer is an agent whose principal controls the manner and means of the work. Manner and means. Ms. Hill argues that we had control, IX had control because we told him to go work for Paul, right? But the manner and the means of the work we had nothing to do with. We did not even know what he was doing day to day. My client does stucco and lathe. He was there doing block work, digging holes, doing framing. None of the things we do, and we certainly didn't direct him on how to do it. That was solely Mr. Muller and Mr. Aguilar, who are employees of Houlihan Construction.
Who made the decision how much that he would earn? The claim that he would earn?
I'm pretty sure the claimant didn't have much of a role there.
No, no, but the claim, but he did.
Well, I think based on the evidence, it was Mr. Houlihan and Mr. Carbonell that decided together what the arrangement was going to be. You know, look, the claimant is a construction laborer, and you know he's probably, I don't know, but he's probably not that sophisticated. And he said he thought he worked for Mr. Carbonell, and in fact there are 3 possible employers in this case: Houlihan Construction, IX Design, Robert Carbonell. Because the claimant says, I worked for Robert. Robert is the one that paid him, not IX Design. He never got an IX Design check on the 9901
Well,
job.
I mean, selection, engagement, and payment of wages are factors
Yes.
to consider. So it's not, you know, even if you're unsophisticated, those are 2 legal factors.
Sure.
Granted, control of conduct is an important one, and we recognize that.
It's the ultimate test, and that's not just from you, it's from the Supreme Court of the state of Florida, because we have the same, whether we go to the restatement of agency, we go to non-workers' compensation employment cases, or we go through the first DCA workers' compensation employment cases. They all say the same thing, that the payment of wages is the least important factor. And the only thing tying IX Design to Mr. Zamora on the date of this accident is the payment of wages. Now, what Ms. Hill argues in her brief is, hey, look, the judge found that Zamora was an employee. And because Zamora was an employee, he must have been an employee of IX Design because we didn't file a claim against Houlihan. And I think that's really a nonsensical argument. Take an employee who works part-time at Target and part-time at Walmart. Falls off the ladder at Target. You don't file a claim against Walmart and say, Judge, I want you to find that Walmart is his employer, because it doesn't matter. The only thing that matters is the identity of the employer in which the claimant was working in the course and scope of that employment at the moment he fell off the scaffold.
Right. Well, in claimant's defense, there's also an argument the ultimate findings of factor are very few here. And this could have been, you know, a more robust order.
Yes, I agree.
And so with that, you know, and this has been put in the briefs, but why wouldn't we send this back for a more robust ultimate findings of fact to get you where you want to be?
Well, at the risk of being repetitive, I will say because they didn't file a motion for rehearing, because an inadequate order, an order that has technical defects in it, is something that's readily correctable if we bring it to the judge's attention and say, hey, Judge, you made a lot of findings, but you didn't make ultimate findings. You didn't say, and therefore I find this, and therefore I find that. And because they didn't file a motion for rehearing and allow the judge to correct it, I don't think they preserved it. And of course, we all know that if you were to reverse and say, for example, I find as a matter of law he was IX Design's employee, right? That's one thing. But if all you do is reverse, finding that the findings of the fact in the order are inadequate, the judge will correct the findings of fact and not change the outcome, and this gentleman goes another 6 months or a year without getting his work comp benefits. You know, and they have, fortunately for Mr. Zamora, they have until June 9 of this year to file against Houlihan. Still don't know why they haven't done it.
Or Mr. Carbonell.
Or Mr. Carbonell individually. So they've got options. And you know, the thing that's of interest to me is I understand when a claimant's lawyer says, well, I'm not going to file against an uninsured employer because that uninsured employer is a truck and a tool belt and there's no money there. But this is a fully insured employer. In fact, at the trial, the lawyers representing Houlihan Construction and their insurance company were there just as observers because they weren't parties. We filed a controversy claim, brought them in. We wanted to have everybody in the room so the judge could find the right employer. They resisted. They said, no, we don't want them in there. We're only filing a claim against you. So the judge bifurcates the case and says, okay, we're just going to go try the IX Design case. So, Your Honors, I think that it's clear that if you follow the indicia of employment and all the case law regarding employment, he was the employee of Houlihan Construction, even though that's not the issue on appeal. The only issue on appeal is whether he was ours. They still have a remedy. And in fact, the sooner you PCA this case, the sooner they'll know it's time to file against Houlihan Construction. So, Your Honors, we hope you won't reverse on the more technical argument about the sufficiency of the order. I agree with Ms. Hill and Mr. Studemeyer, who also agrees with me, that we wish there was a better order. You know, back in the old days, we used to write the orders. And I used to love that. Because the judge would say to the winning lawyer, Mr. Rogner, on those rare occasions when I won, would say, Mr. Rogner, write the order. And I would write the order for you. I would simply write the order, making sure that this was something that was defendable on appeal. Now the judges all write their own orders, and for the most part, they do an excellent job. This particular order has some insufficiencies to it, but that should have been brought to the judge's attention then and not now. We hope you'll affirm the order.
Okay, Your Honor, just briefly. As far as the preservation of error issue, the judge has a statutory obligation to make ultimate findings of fact. And as Mr. Rogner admitted, the findings are very deficient in this case. The judge clearly made basically one finding, and that is that there was supervisory control without anything else. And Mr. Rogner mentions in his answer brief a bunch of findings. The findings I actually find are irrelevant to the issue, but they weren't findings at all. They were essentially the recitation of evidence, with the judge never concluding or accepting anybody's testimony over anyone else's. And there is a lot of conflicting evidence in this case as to who had the right to do what. But one thing I did want to point out is IX is the one who decided what to pay the claimant, and it was always the same thing. And I disagree with Mr. Wagner that he just transitioned from one job site to the other. There was a specific call and an agreement, according to the evidence, that the claimant could go to the new job site. And there was first a call from Mr. Houlihan to Carbonell, and then there was a call from Carbonell to the claimant. I believe everyone testified that consistently. In terms of, one more thing about the personal payments by Carbonell. Carbonell specifically testified that he did not do anything personally. And Houlihan paid IX Designs, and then he just paid the claimant cash because, number one, the claimant wanted cash, and number two, he wanted to avoid payroll taxes. He testified to that. So that's the reasoning. I mean, it's clear in the record. So essentially, Your Honors, I believe that you do have the authority to reverse as a matter of law and find that there was a relationship, an employment relationship between the claimant and Carbonell IX Designs, or alternatively, send it back down to the judge to make the ultimate findings as she's required to do by statute, regardless of whether or not there was a motion for rehearing filed. Thank you.
Thank you, Mr. Rowe.